Hello everyone, and welcome to our first episode of People's Law. I'm your host, Bob Cocco. I've been a practicing lawyer in Philadelphia for over 20 years now, and most of that time I've specialized in the practice area of consumer protection law. My goal in this show is to improve the average person's basic knowledge of the laws that most affect their daily life. To do so, I will have guests from the legal community provide you with useful information to understand your legal rights in different areas of civil and criminal law. So the first topic we're going to discuss involves automobiles. One of the biggest purchases the average consumer makes is buying a car, the other being buying a house. In our show today, we will be discussing two consumer protection law topics related to automobiles: unlawful repossession of automobiles and used car auto sales fraud. To help us understand and discuss these issues, we'll talk to attorney Bill Bensley. Bill, welcome to the show.
Thank you for having me, Bob.
So I'd like to start out by talking about auto repossession, because even though it's something that's popularly understood to occur, I don't know that people from our own practice of the law that people know really what their rights are when these things occur. So I don't want to talk about when repossessions happen in the middle of the night, because that's not going to invoke legal rights as much as the topic that we are going to talk about, and that is when a consumer confronts the repossessor while the repossession is happening. So let's talk about that. If I am a consumer and I hear the repossessor repossessing my car, what is within my legal rights to do and say if I want to confront the repossessor about taking my car?
Good question. I have to agree with you. This is a very little understood area of the law. Scary enough, that's also true of the judges. And yeah, you are the owner of that vehicle. So even if it does happen at night, and a lot of them do, and no matter where that vehicle's parked, if it's on your property, in the supermarket parking lot, on the street corner. If before the repossession agent has possession of the vehicle, you object and unequivocally tell them to stop and go away, as a matter of law, that's exactly what they're supposed to do. Now, oftentimes they will not. These agents work on a commission. They get paid per vehicle that they are able to repossess, and they have a devil of a time just finding the vehicles. So once they've located one, they want to effectuate, is the legal term, that repossession. So if you object, all too often what they will do is hurry up and hook up that car. In other words, take possession of it. So from a consumer standpoint, you're always worried about not only what rights you have, but how to enforce them. And so in this day and age, we're lucky because most people have phones that take videos or take photographs. So if this were to occur to you, the first thing you want to do is to document that you're there and you're intervening, you're objecting before this repossession, before the agent takes possession.
Okay, so let me stop you for a second to summarize what you've just said. So number one, you can say to stop, and there's no magic words, right, to stop the conduct.
There are no magic words, but you want to be unequivocal. You want to avoid things like, well, can you just wait a second? Can you let me talk? Give me a chance to call the bank. You want to avoid that and just tell them no, stop, go away.
Right. Don't be afraid to be bold about it.
Absolutely. Don't put yourself in harm's way, but at the same time, you have the right to tell them to no, stop, go away.
And if you have a cell phone camera, for example, to document that whole exchange.
Very important.
Okay. And does it make a difference? So you talked about the fact that the car could be in a parking lot or on someone's property. What about if the vehicle is parked on a public street? Does that change anything you've just talked about?
Doesn't change anything. Now, if they are on your property, well, there's two things. If they're on their property, and let's say you don't have an enclosed area of property, it's just a driveway or an alleyway or something like that, you can, when you tell them no, stop, go away, you should also tell them, and get off my property now. Now, beyond documenting that you're telling them this, you should if they persist, you should also call the police. Okay? But as you and I know, unfortunately, a lot of the police officers don't exactly know this area of the law, and there at least be some fear that they have too cozy of a relationship with some of these repossession agents, because these repossession agents have to report these repossessions to the police departments. They develop a relationship with the police department.
So you're talking about before they conduct a repossession, they often report it to the police that they're going to do it, so the police know that they're not engaging in criminal activity.
Well, some do, but I was speaking more, there is a requirement under the statute that after the repossession has taken place, that they are supposed to report it to the police department then. The idea being they don't want the police thinking the vehicle's been stolen. So when the person calls up after they get up in the morning and the car's missing, that repossession sort of already been reported to the police.
Let's talk about the police a little bit more. So sometimes, is it not true that the repossessors are the ones who call the police?
Absolutely, and that's the term we've been dancing around or referring to without actually stating it is breach of the peace. The law recognizes that a secured holder, a bank, can repossess a vehicle without a court order, without prior notice, if you're in default, but only if they do so without breaching the peace. And this term is not defined in the statute, but it has been defined in cases over the years. So anything that would potentially result in a confrontation that could turn violent is what is to be avoided.
Let's talk about some examples of that. For
Yes.
example, neighbors leaving the house while the repossessor and the consumer are having an exchange. If he's causing enough noise to have neighbors come out.
Well, even not going away, once you object and tell them not to go away, the law says, well, geez, there's an existential threat that could involve could result in a confrontation that could turn violent. So that's why they're supposed to go away. But yes, if they touch you, if they insult you, if they raise their voice, if they invade your personal space, if they block you in your door, these are all things you and I have had cases involving. Shoving away from the car, trying to body or block you from the car. All of these things are a breach of the peace because, as anybody can naturally imagine, that could really develop into a violent confrontation. That's especially true, as you were just, I think, intimating, where there are family members involved. We've had cases where the repossession agent gets physical with the wife, even in one case, 8 months pregnant. You can see how that could result in a reflexive, very violent response.
And that family member doesn't have to be an owner of the vehicle to have a claim against the
This
repossessor.
protection extends to everybody. Members of the public, neighbors, as you mentioned, members of the family. If there's an objection, the repossessor has to go away.
What if the vehicle's taken and it's being damaged? For example, they hooked it up improperly and it's being dragged down the street and you can see parts of the vehicle coming off. Does that also create an additional claim against the repossession company?
It should. If not a claim as an unlawful repossession, it certainly should be a claim for damage and for negligence. But it probably would result in, the term of art is a commercially unreasonable act, because of course their plan is to sell that vehicle later and apply what they get against your debt. Well, they're not going to get nearly as much for that car if they damage it in the process. So they're held responsible for that. It's a violation of the overriding statute.
So we've been talking about the repossessor's conduct. Let's talk about the finance company or the bank that sends the repossessor out, who's financing your vehicle. And if you fall behind on payments, that prompts the repossession. Let's talk about some things that the finance company may be liable for, perhaps prior to the repossession. So for example, if you're late on payments, I think it's popularly misunderstood. Wouldn't you agree that that you could be a couple days late, it's no big deal, they can't repossess my car, I'm only a couple days late, or I'm 1 day late, but contractually they're allowed to repossess the vehicle.
Right. No, you're right. It's a very strict law. Pennsylvania is not what's considered a right to cure state. There are some states that say before the bank or the holder tries to enforce or effectuate a repossession, they have to put you on notice and then give you a right to cure. Pennsylvania is not that way, unfortunately. So once you're $1 1 day behind, or your insurance lapses, or your car's impounded, these are all standard defaults under most contracts. But the bank is responsible for any of the a repossession agent's misconduct. That's both as usually a matter of contract under the Pennsylvania statute and certainly under a couple of different Pennsylvania statutes.
What about if you're late, but you make an agreement with the bank to catch up those payments in an agreed fashion? So for example, you missed May, but they say, okay, we'll pay half in June and then pay half in July. If they make that kind of agreement, can the bank still turn around and repossess the vehicle?
The banks would say they could. The banks would say, well, there's part of the contract that says you cannot modify this agreement other than in writing. But this happens all the time. As a rule of thumb, if when talking with the bank, they're not threatening repossession, you better be worried about a repossession. They're not going to mention it because they don't want you to hide the car. That would be their fear. If they are mentioning repossession, usually they're just using that as a leverage to try to get you to make a payment. But yeah, they would be could be held to such an agreement. But this is an important part. You'd want to try to document that, either by sending them your own follow-up email or fax or text, something that brings this out of the purely he said, she said arena. Anything that's in writing that documents this contemporaneously would be very helpful to proving that agreement, which is often hard to prove. And don't think, oh, I heard that this line was recorded, so I can just get the bank to turn over that recording. Very unlikely the banks would ever turn over a recording that would be helpful to you.
Okay. And I think it's important for the audience to know that if they are stuck in a situation where they feel they've been treated unfairly or unlawfully, that if they want to call you and have you represent them against the finance company and or the repossession company, are you going to charge them any money to do that?
No, I handle all cases on a contingency fee basis, which, as you know, and we should tell the audience, means I cover all the upfront costs and expenses and then just take a percentage of whatever we are able to recover, plus the reimbursement of costs at that time, but they don't get a bill. And I think that's important. I think that's the way most consumer attorneys should work. One other thing, you mentioned, and this sort of foreshadows the next segment, that the banks being responsible. Oftentimes when we're called about repossessions, we find out there's been fraud in the inception of the contract, so the bank had no rights whatsoever.
That's a good segue into our next segment, where we're going to talk about used car or auto fraud. So we're going to take a short break, and when we return, I'll talk to Bill about used car auto sales fraud. Welcome back to People's Law. I'm your host, Bob Cocco. And to remind the audience, the aim of the show is to educate you about your legal rights in situations that occur most frequently in everyday life. Before the break, I spoke with attorney Bill Bensley about vehicle repossession. Now we're going to discuss auto fraud, more particularly used car auto sales fraud, and what you need to know when you're buying a used car and what to do if you've already purchased a bad used car. Okay, Bill, so let's talk about buying a used car from a dealer, not from a private party. We're only going to talk about dealers. So a common misunderstanding about your rights as a consumer purchasing a used car is, if something is wrong with this vehicle after I purchase it, I can't sue because I purchased it as is. So let's talk a little bit about that and what that language actually does, or what effect it has on a consumer's rights, and what effects it doesn't have, which is probably more important.
Yeah, just like as we were talking about repossession, this aspect of the consumer fraud law as is poorly understood, again, even by many judges. It's misinterpreted or misunderstood to mean buyer beware, or that you cannot make any claim based upon the condition of the vehicle. Also, there is a host of procedural hoops that a dealer must jump through before the car is even sold validly as is or enforceably as is. Do you want us to break that down a little bit?
Yeah, so even just because they say it's sold as is, and that language may appear, it still may not be have the legal effect they say it has.
It almost never does. Let's start procedurally. First, even for them to make the argument the car is sold as is, first the car has to be posted with something called the the buyer's guide, under something called the FTC used car rule. It's also under Pennsylvania statute. That's the white piece of paper most people are familiar with the two big boxes. One says as is, one says warranty.
And it's applied to the window of the vehicle.
It has to be displayed prominently on the vehicle. Many times the dealers don't have it on the vehicle, and they'll slip it into the paperwork and have somebody sign it. That's not enforceable. Get your phone out, take a picture of that car when you first see it. That will show whether that it has that label on it. Secondly, on the contract itself, on the face, it has to have, there's usually several boxes, and it has to have the as-is box checked. But most importantly, and this is where most of it breaks down, if a dealer is going to sell a vehicle as is, they cannot make any affirmative representation about its history or condition or quality. The law says you can, on one hand, tout the vehicle's history, condition, or quality, on the other hand say, oh, we're selling it as is. They're mutually exclusive, they're incompatible.
Let me interrupt you there for a second, Bill. Please. So, because it's important that we talk about the sales presentation, which you just mentioned. So we know that as is not a bar to a consumer discussing a bad car deal that they think they've gone through. And so let's talk about how the salespersons sell the vehicle and how they should sell the vehicle. So if you ask them a question about the car's history, and if they lie about it, is that something that's barred by an as-is representation?
It is not. And yeah, to the point, an as-is, even if it's enforceable or valid, only prevents a consumer from making two very narrow types of claims. Something called a breach of warranty, implied warranty for fitness, or implied warranty for merchantability. It doesn't mean that you can't claim that the vehicle was misrepresented to you in some way, that it wasn't in an accident and it was, or that it's roadworthy and it's not, or that it was formerly privately owned and it really wasn't, it was a rental car, or that has various other specific problems, anything that would make the car not roadworthy, first of all. But it is not a bar to a fraud claim or to a claim under the Consumer Protection Statute. It only affects these two very narrow claims. Unfortunately, a lot of people misunderstand that it's much more broad.
So you mentioned just now accidents that occur prior to the consumer buying the car. Would you agree that this is probably the biggest problem with used car deals, and the one that, on a positive note, creates the most valuable claims for a consumer?
Well, I would agree, and not only for used cars, but for new cars as well.
Well, we'll talk about that.
Okay.
Let's stick with used cars for now.
Okay, that's your show. But yes, it's certainly the lion's share of the cases we handle. But one of the reasons for that is, again, we're talking about when you have a lawsuit, litigation, it's what can you prove? And with an accident, usually you'll have some physical evidence that this vehicle was in an accident before the car was sold. And you then can corroborate that with the records you'll obtain through subpoenas from insurance companies and so on, so it's easier to prove. Can I make a comment about the unibody structure of the vehicle? Because I think that's very pertinent to this issue.
Well, so first of all, yeah, that's obviously the frame, or what you just referred to as the unibody structure of the vehicle, is an important feature of the vehicle. And I think first let's explain to the audience what that is and why that is, and why it makes such a difference in terms of the safety of the vehicle and the value of the vehicle that you're buying.
Right. There's no doubt if somebody tells you the car has not been in an accident, or gives you a clean Carfax, which is often the way they do it now, and it wasn't an accident and only had cosmetic damage, that will still affect the value of the car, and that's still a viable fraud action. But cars, at least for the last 2 to 3 decades, 90% of the passenger vehicles on the road have what's called a unitized frame, or most people talk of it as a unibody frame. Now there's parts of this frame, it's a whole lattice work of welded parts, and there's parts that are called crush or crumple zones, which are made to collapse, to bend during a collision to absorb that energy. And then there's more rigid parts made to deflect that energy from the occupants. The operative problem here is that these frames are made to distort, are made to bend. These frames are made to be damaged.
To absorb the collision in an accident.
Absolutely.
To keep the occupants
and that's
safe.
true of even minor accidents, especially offset accidents where the car is hit on the corner. So you have millions of vehicles that are in what might be considered minor accidents that have serious frame damage. The tolerance for these frames in being repaired is only 3 millimeters, which is less than the thickness of 2 quarters, much less than the thickness of 2 quarters. It's less than the thickness of 3 dimes. And once these specifications are off, once the distortion is there, whether that frame will ever perform again to protect you or your family in a collision, whether the airbags will deploy, because they're based upon a certain rate of deceleration, very narrow window of deceleration on these sensors. It's an unsafe vehicle. You cannot be sure that it will perform in an accident again.
Do the dealers know sometimes when they acquire the vehicles for their sales inventory that the car is frame damaged?
Well, the most used car managers who perform thousands of appraisals of trades and so on a year will admit that they can tell a vehicle's been in an accident within seconds of walking up on it. There are just certain telltale signs that cannot be missed. They're like thunderclaps to anybody with experience.
I'm sorry to interrupt you, but we have to get a couple topics in that you mentioned. I want to make sure the audience picks up on it, because you mentioned Carfaxes, which are very popular because of the TV advertising for them. If someone gets a clean Carfax, is that a guarantee? Should they consider that a guarantee that the car has not been in an accident?
Absolutely not. Carfax has done a wonderful job of marketing their product. It's become, I think, de rigueur for everybody to get a Carfax, and most dealers have to subscribe to Carfax because it's in such demand. But you're right, Carfax certainly does not capture all of the accidents. They don't have access to insurance records, for instance. They really only have access to service records and to state-based accident reports, and not all states even collect that accident data.
What about certified pre-owned vehicles? Another thing that dealerships and manufacturers promote an awful lot in advertising. Similarly to what I just asked you about Carfax, is that a guarantee to a consumer that they're not buying a damaged car?
Well, there are no guarantees.
Right, right.
And I think I've handled many certified used car cases for all the various brands, including the premium brands, and I can state with pretty solid conviction they're all scams.
Okay, I think that's an important conclusion.
Even I'll give you for instance, even with we had a recent case with a premium brand, and we got their audit records. These manufacturers are supposed to audit the dealer's operations, their operation of the certified programs on an ongoing basis, 1 or 2 times a year. And even with this premium brand, we found that the dealerships had violated the program and sold cars with disqualifying conditions in excess of 60% of the time.
Wow.
Yet they get high marks from the auditor because all the signage was good. The vehicles, many times the certified vehicles are supposed to be in a particular area of the dealer, and their numbers. There are ratios and benchmarks they have to reach in selling and offering
So the
certified programs.
manufacturers are more interested in protecting their dealers than they are the consuming public.
They make millions off these certified programs. So many of the operations guys will state explicitly that
We're running out of time, Bill. I just want to make sure that the audience listening to this segment understand the same thing that we talked about in the last segment, which is if they think they've gotten a bad used car deal, do they have to pay you for you to represent them?
I only take cases on a contingency fee basis. If they think they've been, there's a problem with a car deal, they should call an attorney. If their car's been repossessed, even if they don't know if there was anything unlawful, they should call an attorney. I would say at least 50% of the times we get a call about a repossession and there's no claim there. Upon doing some workup, we find there was fraud in the sale.
And the consultation's free too, right?
Yes, that's correct.
Okay, thanks for being with us, Bill. If you are interested in discussing or learning about the topics we covered today, go to the website, phillyconsumerlaw.com. I'd like to thank, again, my guest, Bill Bensley, for joining us today. I also would like to thank you, the viewers, for tuning in and watching. So until next time, remember, take the time to understand and protect your legal rights as a consumer.